Dear students, good morning. Today let us discuss the newspaper 27th January 2016. The first article is related to R.K. Raghavan. Before going into this article, let us recollect few fine points related to corruption. We discussed low salaries plus weak policing and opportunity as equivalent to the corruption. But however, the low salary condition is being revised in India after the 7th Pay Commission recommendations. So in this context, there shall be no reason for the bureaucrats to be corrupt. So only reason that is visible is rather than need, it is more the greed. And the corruption is a low risk, high remunerative activity in India. So the punitive action against the corruption need to be strengthened. So at the highest levels of the hierarchy, the collusive corruption between the minister and civil servant is very high. So the pressure from the minister, the allurement of the better postings, and all these things are making the higher bureaucracy to compromise on its mores and to get involved with the corruption. And that is causing the root, that is causing this cancer to spread very roots of the functioning of the bureaucracy. It is going to erode the confidence of the citizen in bureaucratic fairness and objectivity, which will make entire governance system ineffective. So how to fight this scenario? What are the challenges for the investigative agencies? If you see over here, there was a directive before, an executive directive which says that any person above the joint secretary, if he needs to be inquired or a preliminary inquiry has to be conducted, the government of India's permission is necessary. Now in 1997 it was struck down by the Supreme Court, and an amendment to the CVC Act 2003 and Delhi Special Police Establishment Act 1946 has brought in this provision again. In Dr. Subramanya Swamy versus Union of India case, the Supreme Court has declared it is violative of the equality before law and said no such a permission is necessary. This is a progressive step. But however, at the level of the prosecution or to prosecute a government officer, even today, the permission from the government is very much necessary. So in this context, the delay in giving the permission or not giving the permissions, these are providing an opportunity to be emboldened and involved with corruption. So the minister and civil servant nexus is getting strengthened because the minister is the one person who has to allow for the prosecution against the corrupt civil servant. So here, removing these particular protections is very much necessary. And in the class we discussed one thing. So any anti-corruption law has to protect an honest officer and it has to punish a corrupt individual. It has to act as a deterrent to corruption and an encouragement to honesty. So these laws can be misused against a honest official, that fear still exists. So however, as the corruption levels are high in the country, we need to strengthen the legal mechanisms. And the second thing is the punitive action. If you see the criminal law amendment ordinance 1944, if I am wrong, so this particular law clearly states that the state can attach the properties and confiscate these properties that are acquired through illegal means. So, but these provisions are sparingly used. The reason being is judicial delay. If you can rectify this judicial delay, and if the properties are confiscated, then automatically the chances of corruption are going to come down. So the strong legal measures are the better solutions to fight the corruption. That is what is the argument of the article. And the second thing which I want to focus over here is, see the conclusion of this article. That will be very much useful for you to understand how your essay needs to be closed. Very perfectly concluded the article is. If you have any better conclusions, please write down and send it to me. And the next is related to the climate change. The COP21 was over, the Paris conference. Now, the major issues which are highlighted there are finances and technology transfers to the developing countries. In this case, the technology transfer, it is not just the research and development of a technology, but making it widely accessible. For this, the technology need to be fielded or need to be innovated to the needs of a particular socio-economic conditions. It also shall be made affordable towards the developing countries. So without these, you cannot make the technology to penetrate into the country. If you can take about the silicon panels which have got the higher efficiency, hybrid vehicles, and many other solar buses, etc., many other technologies did not come into the developing countries due to their prohibitive costs. So in this context, so the LED bulbs and their success shows that a right policy environment is also very much necessary to take forward the technology. So in this, the COP16, it has created an institutional mechanism, that is CTCN. So the CTCN, Climate Technology and Network Center. So the CTCN provides for the adaptability of this technology, applicability of this technology across the different countries. But however, the Technological Executive Committee review or CTCN review, they do not provide for a process that is quick and readily available. So in this context, as the time is too short to reduce the emissions of GHGs, the CTCN need to be made effective. Finally, the regulatory framework of the country has to be revisited to make these technologies more adoptable and accessed by the people. The next is about smoking. Here, there are two surveys which are being talked about. The Global Youth Tobacco Survey, Global Adult Tobacco Survey 2009-2010. What are the findings of this? The tobacco smoking is increasing among children, and it is high among the children who are uneducated and also who are involved with the child labor and belonging to the low income groups. So in this context, how we shall reduce the smoking is a question. Now, the Juvenile Justice Amendment Act, it is in the news for various other reasons, but also there are many progressive provisions such as foster care homes, keeping the children away from the drugs and other dependable substances. There are many other provisions in this. So according to the Juvenile Justice Amendment Act, which is recently passed by the Parliament, if any person is selling the tobacco products to the children, he is punishable up to 7 years of imprisonment and 1 lakh rupees of penalty. So, previously, the Tobacco and Other Products Act, the Sale of Tobacco and Other Products Act, it merely imposes a punishment of 200 rupees. So it means there is no deterrence. So now in the implementation of this act, most of the cigarette shops are being unregulated and no prior government permissions are necessary in this country. So implementation of the law is very difficult. And the second thing is, if the tobacco and the cigarettes and use of the Tobacco Products Act 2003, it can be amended to make the cigarette sale itself a deterrent and a discouraged action. Now, no cigarette shop shall come up within the 100 meters distance of a school, and a cigarette smoking, the box shall consist of pictorial warnings that occupy more than 2/3 of the space. Already the Australian court judgment in the previous articles I have discussed, where a plain labeling, so without the branding, this kind of cigarette packet regulations are allowed according to the Supreme Court of Australia. And finally, we can provide for prevention of the tobacco advertisements in the most prominent public places, including the schools and colleges. So these kind of behavioral measures also can bring in a greater change. Now, if you see the cigarette companies, they are very much interested to promote the cigarette smoking to the school children, that is at very young age. because the continuity of the habit will be high if it starts at the young age, and also use of the frequency of smoking also increases if it starts at the young age. So fighting this particular MNCs is a major challenge. Coming to the Denmark's absurd law on refugees. Now, Europe is no more inviting to the refugees from Syria and the Libya. So it was a tide where there was a public response and sympathy towards these refugees after a child died on the shores of Turkey. In this context, the Greece is the major entry point for these refugees, and many of the European countries are recommending to wall off the Greece. And there is no common action across the European Union nations against the refugee crisis. And European major countries such as France, Germany, UK, one or the other way are responsible for this crisis in West Asia and Africa. So here the challenge is this. The recent Denmark law aligns with the Switzerland law. It provides for the confiscation of the valuables from the refugees. So they argue that these valuables are necessary to maintain their upkeep in the country. So in this context, understand the circumstances under which they are coming to the country, and this action of the developed world, it can create major stress and pain among this and bring in alienation. And the rightist factions and rightist government in Hungary and other places, they are more vocal against the refugees. So the religious or else anti-Islamism, a factor has been taken as a condition to fight or else to hate the refugees. So in this context, the need of the hour is not disallowing for the refugees, providing for a pan-European settlement plan, and also providing for or striving for the peace and stability in their own countries, in their motherland. So the very situation is against to the humanitarian order which has been set up in the Europe, or humanitarian rights record of the Europe. Coming to the Arunachal Pradesh saga, so it is still continuing. The Supreme Court has taken up the petition to review this imposition of Article 356 in Arunachal Pradesh. So in this context, we can go back to the S.R. Bommai versus Union of India case. According to this, the Supreme Court can review the imposition of Article 356 and the governor cannot recommend the imposition of Article 356 without any valid material facts. And it can reinstate the government if there are no valid material facts for the imposition of Article 356. You do not look into the correctness of the material, but it looks into the relevance of the material, so which has been the basis for the imposition of Article 356. So this, if in your polity notes under the governor chapter, please visit S.R. Bommai versus Union of India case with regard to the role of the governor. And next is, the Pak court rejects the petitions for the voice samples. In 26/11, India has given various voice samples and it wants the voice of these handlers of terrorists in Pakistan to correlate the evidence. So the Pak court has rejected for providing for any such this voices. And review of performance of the ministries every month. In India, the major challenge is the lack of political accountability. In this case, the Manmohan Singh government has brought in a performance-related incentive scheme. So, on line with this, performance-related incentive scheme, the performance-related incentive scheme exists at the bureaucracy level. So the performance evaluation factors are created, or results framework document. It was created by the Manmohan Singh government at the political level. Now, this RFD, it has been undertaken once in a year exercise. Now this performance evaluation is made into a rigorous process, a once in a month evaluation process. The highest direction from the leadership, it can install motivation and also the spirit of comradeship among the Council of Ministers to deliver the results. And finally, there is an article related to the higher cess. Now, there is ad valorem duty and specific duty. So the difference we need to understand this article. For example, if I buy a saree, irrespective of the cost of a saree, so the 10 rupees is the duty, or 10% then it is specific duty. On the other hand, if the saree cost is, or 10% is the duty, it means the saree cost is 100 rupees, it becomes 110, 1000 rupees, it becomes 1100. So as the cost of the good increases, then the value or else the tax value is also going to increase. In India, with regard to the oil exploration, the cess is imposed as a specific duty, where $9 for the barrel of exploration is been or extraction has been imposed. So it means when the crude oil cost is around $100 per barrel, it is less than 10%. Now, when it has come down less than $30, it is more than 33% with regard to the cost of the barrel oil extracted. So in this context, this particular higher cess, which is based on specific duties, is discouraging for the cane India to continue the production and also discouraging their particular markets. Second, there are many limitations on the export of these oil products, which also discouraging them to discover the prices and also to take up something called as international markets. Finally, the retrograde taxation is one thing which is very painful for the corporates. So from all these things we can say that India's business conditions are not very favorable. So the Cane India says that the oil business is very risky in India compared to Iran and Saudi Arabia. So these are the articles which are important for the day, and all the best. And now I want to announce you that Mr. Safir Karim, Dr. Raja Dayanidhi. Safir Karim is being trained as an IPS officer. Dr. Raja Dayanidhi is an IAS officer who got selected in the first attempt. And Mr. Venkateswar Rao Kalluri, who is an IRS officer. They are part of our mentorship program on civilsprep.com. So we welcome them to our platform, and also we welcome them towards supporting us. Finally, so almost another 20 to 30 people will be launched as mentors very soon, and we are planning to develop an individualized mentorship program where a person will take 2 people and he will regularly for 1 month he will correct the answers of those 2 people. So I encourage you to write more and more answers, sir. Thank you very much. All the best.